In this video, I want to take a look at a case there that was decided in the Supreme Court, and it's the Nano Nagle case. The Nano Nagle case started out in the Labour Court. It was appealed to the High Court. It was appealed to the Court of Appeal, and then ultimately it ended up in the Supreme Court. The reason why the Nano Nagle case is so significant, so important, is because it allows us to see what the Supreme Court has decided in relation to an employee in the workplace with a disability, and what is the obligation or the extent of the obligation of the employer to make reasonable accommodation. So in the Employment Equality Act, it's the Nano Nagle School versus Daly. It's a 2019 decision in the Supreme Court. It had been, as I say, at other venues as well, Labour Court, High Court, Court of Appeal, but the Supreme Court handed down a decision in 2019. The question is to do with Section 16 of the Employment Equality Act 1998, which it makes provision for a person having reasonable accommodation made for them if they're unable to perform their entire job, all of the duties, all of the tasks attached to their job, that the employer must make reasonable accommodation and take appropriate measures for the employee in order to allow them to have access to employment, to participate or advance in employment, or to undergo training. However, the reasonable accommodation and the measures that the employer must take cannot place a disproportionate burden on the employer. The question is then, what was proportionate, what's disproportionate, and so on. The Supreme Court basically says in this decision that Section 16, subsection 1 of the Employment Equality Act 1998 sets out a premise. That is, that an employer is not required to retain an individual in a position if that person is no longer fully competent and available to undertake the duties attached to that position, having regards to the conditions under which the duties are to be performed. However, it does carve out an exception, and there is an exception, and that is if reasonable accommodation can be made for the person to undertake duties, undertake their job. The decision goes on to say that this does not, of course, mean that the duty of accommodation is infinite or at large. It cannot result in removing all the duties which a disabled person is unable to perform. Then, almost inevitably, it would become a disproportionate burden. It goes on to say that it is, therefore, the duty of the deciding tribunal to decide in any given case whether what is required to allow a person employment is reasonable accommodation in the job, or whether, in reality, what is sought is an entirely different job. So, the conclusion that you can draw from the Supreme Court is that the employer certainly has an obligation to make reasonable accommodation for an employee with a disability in order to allow that employee carry out the duties and roles and tasks attached to that position. However, the obligation does not oblige the employer to create a new position. And in this case, the employee, I think, lost ultimately the Supreme Court decision. It was between Daly and Nano Nagle School, or Nano Nagle School versus Daly, Supreme Court decision. Very important. But the takeaway is that whilst the employer has an obligation to make reasonable accommodation, it's not an open-ended, not an infinite obligation, and even leaving aside the question of disproportionate burden, the employer is not obliged to create a new position. What they must look at is whether they can make reasonable accommodation for the employee to carry out the tasks and duties attached to that position, the one they occupy. And as I say, the employer is not obliged to create a new position. You can have a read of the full decision yourself there. Supreme Court decision, Nano Nagle School versus Daly, 2019 decision. It's on my website, employmentrightsireland.com. If you go to the website, just there's a search box there on the top right of the website. Stick in Nano Nagle. There's a few articles, a few blog posts about that particular decision. Have a look though for the one, guidance from the Supreme Court in the Nano Nagle reasonable accommodation case. Hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below. Thanks for watching.